good day. Over here at Blacklisted News, Drug Task Force officer denied qualified immunity for violating citizens' rights with illicitly obtained no-knock warrant. Okay, this is back to a story. Well, let's just read it. The law enforcement community and their love of no-knock warrants is starting to cost them. Multiple lawsuits have been filed over the past several years because of these tactics. And just last month, a cop was shot dead by a homeowner defending himself against armed attackers who bashed in his door unannounced at 5:30 a.m. in the morning. The sick twist to the last incident is that the homeowner is now charged with capital murder, an offense that is punishable by death in Texas. Now another suit stemming from a no-knock warrant has gone badly for the law enforcement officer behind the raid. Michael Riley, an investigator for the Rensselaer County, New York Drug and Gang Task Force, is now facing the possibility of a jury trial, all without the safety net of qualified immunity, according to the Second Circuit Court's opinion. This is how the no-knock raid went down. On July 3rd, 2008, at approximately 6 a.m., McCauley was woken in her home by the sound of the City of Troy Police Department Emergency Response Team, ERT, knocking down her door and the explosion of a flashbang grenade. Dressed in all black, wearing face masks, and carrying automatic weapons, the members of the ERT screamed for McCauley to get on the floor, but as there was not enough space for her to lie on the floor, a member of the ERT instead shoved McCauley face down onto her bed. As she had been roused from sleep, McCauley was clad in only a t-shirt and underwear. She repeatedly requested to cover herself, but was repeatedly denied. This raid in search of crack cocaine was based on a confidential informant statement that had visited that particular address 20 or 30 times during the previous 6 months to make drug deals. The task force placed the house under surveillance to verify the informant's claims, but noted no drug-related activity. Riley then ran a background check on the house-listed occupant, Ronica McCauley, which came up clean. The report indicated she had no criminal background and additionally noted that a child resided in the house with her. Riley then acquired a no-knock warrant based solely on the informant's unverified claims, omitting everything the task force had observed, that being nothing, as well as the results of the background check. Judge Pooler dissembles exactly how Riley lied by admission to obtain this warrant. So we got the judge is now rolling on the cop. Okay, remember that judge is an attorney. Okay, and I've been telling you that these guys, attorneys, corporate counsel attorneys, judges that are really attorneys, okay, they use the cops as the fall guy. Alright, they set them up by indoctrinating them with all these ideas that the cop's going to be protected and have immunity and stuff. When things go south, nothing can be further from the truth. Okay, and there's the court case down here. You can read it, 86 pages. I'll leave the link. But you know, this is what happens. First, you show the sheeple a bunch of fear-mongering, then take away their right to bear arms, then sell them the right to bear arms whilst fear-mongering. Then they tell cops to go in their homes without knocking, but simply breaking down the doors. This is a clean way to kill cops and citizens both, facilitated by Congress. Now, we go over here to the Supreme Court Justice predicts internment camps in America's future. Okay. And distinguished member of the U.S. Supreme Court gave a sobering reminder of how history can and likely will repeat itself when the conditions are right. Yeah, when they make it right. Supreme Court Justice Antonin Scalia. Okay, I got news. Under the public law, yeah, there will be internment camps. They're not going to be for citizens. They're going to be for you, the attorney. Okay, so this is time to choose your side.